they're acceptable as such. So, and of course, our project officer with Ecology was active throughout the entire process as well. So we got feedback from him as those other work products were developed. But those, I guess what I would clarify is that those, the inventory characterization, the restoration plan, the cumulative impacts, those aren't documents that the Ecology will formally review during their review of the SMP document. It's just supplemental information.
So, and just so everybody's clear, when we do adopt this resolution, it doesn't immediately replace our code. It first has to go to the Department of Ecology. They can accept it in whole, and they can send it back to us with requested changes. And
so even a little bit more to that, Ecology is required to hold a public hearing in our county. So there will be another opportunity for the public to provide input. When Ecology holds that public hearing and provides a comment period, they will forward all of those comments to DCD to respond to. And so that's another step of this process before we would have, even if Ecology approved this as is, there's still that step in between before it could ever become final locally.
so then we would get something from Ecology, though, that they were found acceptable, and that would be before us, but then we'd have an opportunity to change it again and then send it back.
Yeah, the final step would be a board action by ordinance adopting the plan. So if Ecology said it was great and done, you could then approve it locally. If they say it's okay except for a few changes, then we would need to determine how much of a process we need to do locally to accept or modify the requested changes.
And if through all that public process, something came up that hadn't been considered, which is hard to imagine considering how many ideas have come forward, but certainly possible. If something came forward, concern or different way of seeing it or something, and we wanted to make a change that Ecology hadn't envisioned, if we made that change, they'd have to send it back to them like we are today, and then they'd send it back to us. We'd have another hearing.
I think it would depend on the issue, but it's possible that could occur.
If it was a substantive issue, probably.
Yeah.
If it came back from Ecology and you proposed something that they didn't agree with, it would have to go back to their public hearing process.
Yeah, probably.
Yeah. I created this chart. It's also on the web. I've seen it on the web, and I can make copies for citizens. And I only brought one copy, but I hope you guys have seen this before. There's three options that Ecology has: approve and submitted, recommend changes that would make the proposed SMP approvable, or deny if no alteration of the proposal would likely be consistent with the SMA and the applicable guidelines. That's an alternative we're not hoping for, obviously. And if that happens, then it has to go back to square one and have to go back to the county to do it again. And so then there's different processes, but the ultimate thing is to have it come back from Ecology, with scheduled question on Ecology, and then you have to adopt an ordinance to put it into the development regulations, which are found in Title 18 of the Jefferson County Code.
Yeah, in fact, the way I understand it is when Ecology sends you the letter saying, okay, this document is good to go, we're ready to adopt, as soon as this body accepts their adoption, they adopt immediately upon receipt of the letter from you that the changes or the non-changes are acceptable. So it's important to make sure that the document that the state is adopting and the document that you're adopting here by ordinance are the same document.
Another question on page 6-5, number 7. states the county shall recognize and apply a buffer or setback established by an existing plat or a development agreement consistent with RCW 3670. For purposes of this document, then, is a SPAD considered to be a development agreement?
No,
It's not.
no.
It is not, but if you look at the proposed resolution, we did bring that up. I remember which number
Number
153?
147,
147.
and I had collected.
Yes.
Yeah. So I'll just read it. In light of the recent Abbey Road decision from the state Supreme Court, the board hereby restates its intention that an approved site plan approval advance determination or SPAD vests the application to the then existing Shoreline Master Program. The BOCC further finds that it has expressed this intent in the locally approved SMP Article 2 definition of a SPAD, but may opt to additionally express this intent in the regulations found in the proposed locally approved Shoreline Master Program at Article 6(1)(d)(7). So, with legal changes being what they are, things can tend to be a moving target in compliance. But it has certainly been the public's understanding and the county's belief that SPADs that are approved would be vested after the adoption of the Shoreline Master Program. So,
And they would be vested to the SMP in place at the time they were approved.
basically the standards that the SPAD was reviewed under. And so, because of timing, we felt that putting it in the resolution made it clear to everybody what our intent is and what our interpretation would be, so that as we move forward, if that's a topic of contention, it can be discussed.
Importantly, I think we want to bring this to the attention to the State Department of Ecology, which under the Shoreline Management Act, as Michelle and Stacie have indicated, has to approve the SMP before you take final adoption action. We believe it's important that the commissioners flag this to the state's attention so that they are approving that vesting provision.
In fact, this recent decision really was just like 30 days or so.
Right.
It was October 8th. I think I think out October 8th.
So just a little over a month ago, so.
And I discussed it in my vesting manual, which is on question 14, which is part of the correspondence to you guys. It's in the packet.
Right. So, yeah, just interesting that there's an issue after when you talk about these hundreds of points, of public process that didn't come forward. All this over the last few years until after this decision.
So it's our anticipation that the Department of Ecology will be holding a public hearing. And through that process, in flagging this issue to the Department of Ecology, hopefully through the public hearing process, that may open the door for if commissioners and if DOE would be agreeable to it, potentially further clarifying the vesting issue in the element of the SMP that Michelle has cited to, Stacie cited to. But not absolutely necessary that happen, given the way that